Hey everyone, and welcome. Today, we are going to tackle something that trips a lot of people up, but is absolutely essential in any criminal trial: the rule against hearsay. We're not just scratching the surface, though. We are diving deep into the really fascinating exceptions that can literally make or break a case. So I want you to picture this for a second. There's been a crime, and there's one person who saw exactly what happened. They're the key witness. But by the time the trial rolls around, they're gone. Maybe they can't be found, or maybe they've passed away. So what happens? Does their story, that crucial piece of the puzzle, just disappear forever? Well, not always. And that, my friends, is where it gets really interesting. Okay, first, a super quick refresher on what hearsay even is. You can basically think of it as courtroom gossip. It's secondhand information. So imagine a witness gets on the stand and says, "Yeah, my buddy Dave told me the getaway car was blue." That's hearsay. Why? Because the court wants to hear from Dave. He's the one who supposedly saw the blue car. He's the one who needs to be on the stand. And this right here, this gets to the absolute core of why this rule exists in the first place. You see, it's all about protecting a really fundamental right, the right for a person accused of a crime to confront their accuser. You can't cross-examine a story someone else is telling. You need to be able to look the original person in the eye and question them, test their memory, and see if their story holds up. Okay, so here's our game plan for today. We're going to look at what happens when a witness is unavailable, what happens when they are in court, we'll cover a really cool exception about someone's state of mind, and then we'll wrap up with why this legal balancing act is so incredibly important.
All right, let's circle back to our missing witness scenario. In a criminal case, if the person who made the original statement can't testify, their story isn't just automatically tossed out. But, and this is a big but, for that statement to be allowed in court, it has to pass through some very specific and very strict legal gateways.
Under Section 65, these are the four main gateways we're talking about. Now, while they're all important, we're going to zoom in on the two that cause the most debate and really show you how complex this all is: Gateways 2 and 3. So, this first test we're looking at is all about the circumstances. Was the statement made so soon after the event that it's unlikely the person had time to make something up? The key word to focus on here is fabrication. The court isn't asking, could this person have been honestly mistaken? It's asking, do the circumstances suggest this person was deliberately concocting a lie? Now, we get to the third gateway. At first glance, it sounds kind of similar, right? But believe me, this one sets a much, much higher bar. Here, the judge has to be convinced that the circumstances make the statement itself highly probable to be reliable. That is a way tougher standard to meet.
So let's put these two head to head, because this is where you can really see the difference. On the left, unlikely to be fabricated is a lower hurdle. The court's main worry is about a deliberate lie. Was this story just made up on the spot? But on the right, for something to be highly probable to be reliable, well, that's a whole other level. The court is looking at everything to decide if the statement itself is fundamentally trustworthy. It's a subtle legal difference, but it has huge consequences.
Okay, so that's the deal when a witness is missing. But what if the witness is there? What if they're sitting right there in the courtroom, ready to take the stand? Well, as you can probably guess, the rules change all over again. Oh yeah, it absolutely does. When the witness is available, any statements they made before the trial can become way more important. They're not just used to show they're telling a consistent story. They can actually be used as evidence of the truth of what they said, but only if they pass one very important test. And that key test is whether the event was fresh in the memory when they made that earlier statement. Now, fresh doesn't just mean it happened 5 minutes ago. The law is more flexible than that. It recognizes that some events, especially really traumatic ones, can stay crystal clear in our minds for a long, long time. So how does a court figure this out? Well, they don't just pull out a stopwatch. A judge is going to look at a bunch of things. What was the event like? Was it something you'd never forget, or just a routine Tuesday? They'll look at the witness's age and health. And of course, they'll consider how much time actually passed. It's all these factors together that help them decide if that memory was truly fresh. And that brings us to our final exception. This one is really unique because it can apply whether the witness is available or not. You can think of it as the law giving the court a rare window right into what was going on inside a person's head at a very specific moment.
This is Section 66A, and it allows statements about what a person was feeling or thinking or intending at the exact moment they said it. So, for example, if someone says, "I'm terrified of him," right before an incident. That statement could be used to prove what their state of mind was, their fear, at that precise time. It's incredibly powerful stuff because it's so immediate and so personal.
So, after all of these sections and gateways and tests, you might be thinking, man, why does this have to be so complicated? And you know what? That's a totally fair question. The reason is that the law is constantly trying to perform a very, very delicate balancing act. And this is the balancing act right here. It's like a legal tug of war. On one side, you have the absolute cornerstone of a fair trial, the right to confront your accuser. But on the other side, you have the court's mission to get to the truth, and that means it needs to hear all the important evidence. These exceptions we've talked about, they are the law's best effort to try and make those two powerful ideas work together.
All right, let's just quickly tie this all together with a little cheat sheet. If the witness is unavailable, their statement has to get through one of those tough reliability tests in Section 65. If the witness is available, their earlier statement can come in if the memory was fresh under Section 66. And finally, for those statements about what someone was thinking or feeling at that very moment, Section 66A applies no matter what.
So, it all boils down to this one huge question. In the search for justice, how do you balance the undeniable rights of an accused person against the need to hear a story that might otherwise be lost forever? The rules we've gone over are how the system tries to answer that question today. But figuring out if they get that balance right, well, that's a debate that's at the very heart of our legal system. Thanks so much for tuning in.